Good afternoon, everyone. This is Jeff Gray. I'm a partner in Miller Johnson's Employee Benefits Group. Thanks for joining us today on our quarterly benefits update lunch break series. We have these roughly quarterly. This next slide shows our future dates here in July, September, and November. We're still working on topics for these. So if you have any ideas for topics you'd like to hear something specifically, please let us know, and we'll take that into account. We appreciate any suggestions people might have. So for today, I think there are a few people still joining us here at 1 minute after noon, but for today we're talking about a benefits litigation. So my thought here was to give everybody just an update on what's going on some new benefits litigation and some old benefits litigation. We'll start talking about 401k litigation. We've been talking about that for years. That's been going on pretty steadily since around 2008. But we continue to see settlements in these cases. And we've had some recent types of cases involving 401k plans that relate to the use of plan forfeitures. So I wanted to cover that issue today. We also very recently, within the last couple of months, have seen, I believe, 4 new class action complaints related to pension risk transfers. This is what happens when your pension plan is frozen and you decide to get out of the pension administration business and move it over to an insurance company. Something that's been going on for many years has suddenly become the target of some class action lawsuits. Similarly, we've got some class actions related to defined benefit plans and how they define actuarial equivalence. We don't have any cases or any final decisions on those, so I only have one slide. We'll spend 5 minutes on that. And then recently this year, there's been more lawsuits against health and welfare plans under ERISA, specifically a significant case involving a pharmacy benefit manager that I thought was worth covering as well. So with that background, we can just jump into it. What this slide shows is just a chart of recent settlements in the last 12 months that relate to ERISA claims under retirement plans that target kind of like basically the 3 major issues in these cases, which are excessive record-keeping fees, excessive fees paid for investments, and underperforming investments. So just as a brief background, these lawsuits basically allege that the plans fiduciaries have breached their fiduciary duty under ERISA by allowing plan participants to overpay for things like record-keeping fees and investments. So just again, background, under these plans that are covered by ERISA, fiduciaries have a duty to act prudently and in the best interest of participants when it comes to the use of plan assets and the selection of investments that are in a fund lineup. And so you'll see in this chart, within the last 12 months, there have been some fairly sizable settlements, although, the first one at the top for the Xerox plan, that Xerox plan is probably enormous, and it's only a $4.1 million settlement. Participants probably received a tiny amount of money individually, but the lawyers, of course, get their fees paid, and then there is a multi-million-dollar settlement. That's the case for most of these. The settlements towards the bottom occurred within the last few months. So there've been several within the last, say, since March, April timeframe. And in those cases, those are class actions where the parties have told the court, yes, we've agreed to a settlement, and we'll give you the details to approve, by say July or something. So we just don't have the details on what those settlements are. But you can see from the list that these cases continue to get filed, and they continue to be settled. Unfortunately, it's just oftentimes in the best interest of the plan and the employer to put this behind them and move forward. But there are some general takeaways again from these cases, and I won't spend a ton of time here because we've covered these 401k fee cases extensively in the past. But still, these generally turn on whether the fiduciary committee has a prudent process for assessing the investments and the expenses that the plan is paying for service providers. Now, that doesn't necessarily mean that you'll avoid a lawsuit. One of those cases on the prior slide, the employer lost a motion for summary judgment, basically because the plaintiff's paid expert said, well, this fund or the other fund that the plaintiffs alleged underperformed other funds was just on the watch list for too long, in his opinion. That was enough to get that claim about a series of underperforming funds to move forward to a trial. The judge basically took the position that whether they were on the watch list for too long or not, that's a factual inquiry to decide at trial. And so there's no doubt that was a large plan. There's no doubt that committee had a professional advisor saying, yes, nothing has changed in this fund. There's been no change in management or methodology. It's just underperforming for a period and it will likely return. We think it's a good idea to retain the fund. We don't think it's a good idea to force everyone to sell that fund by exchanging funds with it at this point, by sort of selling out at the low point when it's underperforming. So I'm sure that this employer was getting advice to keep it on the watch list. But again, that in the judge's mind, that was a factual decision that justified going to trial. So you can have the most prudent process in the world. It's not a guarantee that you won't get sued, but it's certainly at a minimum what you need to succeed in the litigation. The other issue continued. We should all be continuing to push service providers on fees. When you look at these cases, there's often a kind of dramatic disconnect between what the plaintiffs say should be, say, investment fees or record-keeping fees versus what the plan is paying. And it's, sometimes the allegation is just, hey, look at this 401k averages book. It's a $100 book that you can buy on the internet that just summarizes what the average fees are that plans pay by size. And the plaintiffs come forward, they say, hey, this plan's paying, each participant's paying $80 for record-keeping fees, but plans this size average more like $25 or $35. So we should continue to encourage the fiduciaries of these retirement plans to push providers on fees. You can also, there are experts out there who will do this for you. If you have a very large plan, it may make sense to look at some outside advice just to do that benchmarking for you and look at all your fees, across the board, the investment fees, the investment advisor fees, and the record keeping fees. Because what I sometimes see is that a client will say, yeah, we did benchmarking. Our investment advisor said that our fees are average for a plan our size. But really, the arguments in these cases usually relate to a fund or a series of funds that is more expensive relative to its benchmarks. And that doesn't always come out when you're just benchmarking sort of your overall fees for the plan. These complaints also allege that the plans should have conducted RFPs for vendor services more often. The allegation is usually that the plan should have been doing this every 3 to 5 years. My sense is that clients think that that's too often, but keep in mind that you can do an RFP, which is a request for proposal. It's basically what your procurement folks may call going to market. That you do that every so often. It doesn't necessarily mean you even have to change providers, but oftentimes it'll bring down the current provider's fees. It's just a good exercise to go through. The other issue is, fiduciary committees often have advisors. They'll have a fiduciary investment advisor. They're talking about the investment performance, the costs of investments. It's just become more important, I think, in the minutes to document that the committee was actively engaged in that process and not really kind of passively just taking in the information and going along with whatever the recommendation is. The committee may very well need to do that. The committee members are not necessarily experts, but it's good to document that there were questions about the investment advisor's recommendations, particularly if there is a fund that's on the watch list and you're keeping it, most likely for good reasons. It's just good to have documentation explaining why that fund is being retained or why it's being removed. Finally, I know that there's a case currently pending now that had a recent hearing involving a motion to dismiss, where the plaintiff's expert basically said that there was no reporting from the committee to the board. And so one of the places, if you're a plaintiff's attorney and you want to really really exert some leverage for a settlement, you sue the board members. And technically, under ERISA, even if the board has delegated these fiduciary decisions to a committee, there's still an obligation on the board to monitor that committee. And what happened in this case is basically the plaintiff's expert said, yes, there were never any reports to the board. So the board basically turned a blind eye to this committee, and therefore the board is still a viable target for the lawsuit. So one suggestion there, if you have a committee, there should be a formal delegation to that committee from the board and some level of updates and communication reporting from that committee to the board. In terms of new cases, so those are the old standbys that we've had for many years, but recently plaintiffs are now alleging that that employers are breaching their fiduciary duties under ERISA in the way in which they use plan forfeitures. So ERISA, of course, has, as I said earlier, fiduciary duties of prudence. You have to behave as a reasonably prudent person under the circumstances and act solely in the interest of participants when it comes to things that are fiduciary decisions. We don't necessarily have those duties when it comes to what we call settlor functions, which are things like deciding the level of a matching contribution or whether to even have a plan. Those are all company decisions that are kind of outside the scope of fiduciary duties. But for fiduciary decisions, there are these duties of loyalty and prudence. So many plans, for many years, I think since the 1960s, have had language in them that say, all right, if there are forfeitures in the plan, and of course, forfeitures are money that's basically left over when somebody leaves employment and they're not fully vested in their accounts. So maybe they're 50% vested in their employer contribution. They leave, they take a distribution. The remaining 50% of those employer contributions are forfeited to the plan and they stay in the forfeiture account. And of course, the IRS wants us to use those forfeitures every year. And so what many plans will say is that for those forfeitures, you can use them to either offset future employer contributions, pay for administrative expenses of the plan, or allocate them to the participants. It kind of gives the employer the discretion of how to use those forfeitures. And that comes from an IRS regulation back in the 1960s. And that plan language has been approved many, many times by the IRS since then. But the allegation that the plaintiffs are making in these cases is that that's all fine and good what your plan says, but how you implement that, how you make that decision about how you use those forfeitures, that's a fiduciary decision. You're basically implementing the decision of how to use the forfeitures. You've got these options, basically the selection of those options, that's a fiduciary decision. So by deciding to offset the future employer contribution by those forfeitures, you're in effect using plan assets to benefit the employer, is the allegation. So there's the alleged fiduciary breach there. There's also a provision in ERISA that says you can't use plan assets to benefit the employer outside of certain very limited circumstances. And so also there are prohibited transactions, of course, if you use plan assets and send those assets if the employer buys something from the plan, for example, or if you send assets to the employer from the plan, those are going to be prohibited transactions that are separately prohibited and subject to different penalties and excise taxes, unless the particular exception applies. And so the allegations here are just basically that this whole process where the employer reviews the forfeitures at the end of the year, decides, instead of allocating them to participants or paying for plan expenses that the participants would have incurred, that the employer is breaching its fiduciary duty, engaging in prohibited transactions, and allocating those forfeitures to offset its own employer contributions to the plan. And again, this is a common approach. We have many employers that do this. Everyone was sort of under the impression that this was completely fine, partly based on the IRS approving these plans for so many years. We'll see how they turn out. Here's the list of them. I think all of them so far are filed in California. They're all, like the fee cases, they're all kind of targeted at these enormous plans, because why would you make these allegations and go through the trouble of suing a small plan with small forfeitures that have been used to offset employer contributions, when you can sue these large plans that have spent millions in offsetting employer contributions? So a couple takeaways from these filings. Again, these are just allegations at this point. There's been no court that has approved, validated these allegations or ruled against an employer. They're very recent, but there are some things to, I guess, consider, think about. One is know what's in your document. So using forfeitures in a way that isn't expressly permitted under the plan is going to be a problem no matter what, kind of outside these cases. What we think is the impetus for these cases is actually a 2017 case by the DOL against an employer who was using forfeitures, I think, to offset its employer contribution, when simply that language was not in the plan. These new cases say we don't, even though the language is in the plan, the decision as to how you select from those options is itself a fiduciary breach. But the point here is that, as an initial matter, know what your document says about how you use forfeitures at the end of the year. The other option to, I guess, think about, again, even though these are allegations at this point, if you're an employer who routinely, as a matter of course, uses the plan forfeitures to offset employer contributions, it may make some sense to just take that discretion out of the document. The document could be amended to, for example, just require that those forfeitures be used to offset future employer contributions. And then if there are any left over, to be used for plan expenses, and then whatever's left to be allocated to plan participants. What that would do is basically take the discretion out of what to do with those forfeitures. It's just purely based on what the plan says. And drafting the plan for that sort of ordering rule would not be a fiduciary function. You're just deciding what the benefits are going to be, and then you're just applying what the plan says. So I think that is potentially a viable approach. It wouldn't do anything about the past, but it may help, going forward, avoid some future lawsuits if these are successful, and if they start to spill down to smaller and smaller plans. It may be advantageous to have this revised type of language in the plan document. And there's usually a way. You'd have to check with your document provider. It may not always be evident how exactly you'd go about this, but there's usually a way, even in pre-approved plans, to make that type of an adjustment. You can also, I guess, consider whether offsetting employer contributions could be in the best interest of participants in some cases. If you have a discretionary profit sharing contribution every year, and that's what you're using the money for, and you would have made a lower profit sharing contribution had you not had the forfeitures to use, then clearly in that case, I think offsetting the employer contribution becomes in the best interest of participants. You're basically just making sure that the participants get a bigger discretionary contribution because of those forfeitures. If you're going to take that approach, again, we don't know whether that would necessarily be successful or not, but there's some logic to that, and it may make sense to document that if you take that approach. So that's kind of the status of 401k and 403b litigation. I'll turn now to these very recent pension risk transfer cases. And again, this is very important for anyone with a frozen defined benefit plan or an active defined benefit plan. If you don't have a pension plan and never will have a pension plan, this is probably less relevant for you, but might still be interesting just for your awareness. So with a pension plan, there are various circumstances where this risk transfer situation could come out. You might have a group of retirees who are getting payments, and you just want to annuitize those payments and move those to an insurance company. Or your plan is terminated, you've decided to move the whole plan to an insurance company because you, as the employer, you're in the business of making and selling widgets, not administering a pension plan for people who are not even accruing a benefit under it anymore. This has been a common practice. It's been non-controversial for many, many years. There was an initial Supreme Court case, I forget how long ago it was, that kind of looked at this practice, and there were no issues. So this has kind of chugged along as a industry practice for decades. The background to this is that there was an insurer that failed, I think in the 80s, in the context of one of these pension risk transfers. And so the Department of Labor actually issued some regulatory guidance, not a formal regulation, but something called an interpretive bulletin in 1995. And that bulletin describes what the employer's duty is in selecting an insurer. So the selection of the insurer in this context is a fiduciary decision. And under this DOL guidance, employers are required to select the safest available annuity provider. And that's kind of defined in the guidance. And really no insurer has failed since this guidance was issued in 1995. So it seems to be working pretty well, but as we'll talk about, there are changes afoot. We've had a big uptick in this in the last couple of years. In 2023, I think, was the highest number of pension risk transfers, over 700. So you have 700 employers with sometimes very, very large pension plans moving money over to insurance companies. So you've got all this kind of this high activity going on. There's millions of dollars at stake. There's tens of thousands of participants, and could be in any single plan. So this has gotten the regulators are now looking at this even more so. There's a provision in Secure 2.0 that basically tells the Department of Labor to issue a report on whether or not changes should be made to that interpretive bulletin. So the Department of Labor is looking at this. They were supposed to issue a report at the end of 2023. It's still in the works, but we've heard recently from the DOL that this is expected in a few weeks. And so we don't know what will happen. We suspect that there's going to be more obligations on the employer when it comes to selecting the insurance company. Because of course, when this happens, you take all of the plan assets, send those assets to the insurance company. The insurance company at that point becomes responsible for all of these retirement benefits, not only for paying for them, but also for administering them. So there's a cost in doing this. The plan, the employer incur a cost. If the plan's underfunded, for example, and the employer needs to make up a contribution to make this happen, the employer could be motivated, for example, to choose a less expensive insurer in some circumstances. And so that's part of the idea with this DOL guidance is that, well, you can't just pick the least expensive insurer. You've got to pick the safest available insurer that you can. There's also some new notice and disclosure obligations for lump sum windows that separately Congress and the Department of Labor are concerned that participants just don't understand these lump sum payments. And so Secure 2.0 has these new rules that require additional information to participants about the actuarial factors used in the lump sum calculation, for example, some more disclaimers. And then there's also this report that will have to go to the PBGC in connection with any of these lump sum windows. That this whole set of regulations basically becomes final when the Department of Labor issues its regulations and model forms, which just hasn't happened yet. So these are not yet a factor, but we've got new regulations in terms of notices and in terms of selecting the annuity provider. And with all that background, now we have 4 class actions related to these pension risk transfers. They're against very large companies, again, AT&T, Lockheed Martin, and Alcoa. And they all target the selection of a particular insurance company called Athene. Athene has done this for many years. It's a major pension risk transfer insurer. But the allegation from the plaintiffs is that because it's owned by a private equity firm and also has related entities in Bermuda, that's just inherently more risky than selecting what the plaintiffs call more of a traditional insurer, like a Prudential or Principal or something like that. So the theory is both the nature of the ownership and what they call the offshore structure. Because of those, no reasonable employer would make the fiduciary decision to select this particular insurer. And the allegation then is that, well, if you've got a group of insurers, very large professional insurers, and you pick the one with a Bermuda reinsurance structure, you must only be doing that to save money for the plan. That's the theory. That's the argument anyway. And the demand in the AT&T case, for example, is that selecting that less expensive insurer saved the employer $363 million, and that the employer has to make that up back to the plan participants. Again, these are very recent claims. We don't know what will happen with them, where a court will take them, but we do want you to be aware of this if you're considering basically be aware of all of these issues if you're considering a plan termination or a pension risk transfer in the near future. There are also lawsuits currently pending against pension plans related to the way in which the plan calculates participant benefits. Basically, pension plans are designed to pay an accrued benefit in a normal form, basically the participant's single life annuity at the participant's normal retirement date, which is usually age 65. And so if that benefit's paid in a different form or at a different time, the plan needs to actuarially adjust that benefit to benefit amount to equalize it. So if I take it early, I'm getting the same benefit as I would if I took it at age 65, or if I take it after age 65, it's actuarially increased, for example. So there's no specific law about how a plan should go about defining what those actuarial equivalent factors are. ERISA just says they have to be actuarially equivalent. And so what these plaintiffs maintain is that the assumptions used in doing that calculation are just unreasonable. They're using an unreasonably high interest rate, or an unreasonably old mortality table. And so, for example, if your interest rate is too high, then the payments will be lower. So a lot of these plaintiffs are saying, hey, the interest rate the plan's using at 7% or 8% should really be 3% or something. But what fundamentally, there's been no court yet that has said that that requirement of having an actuarially equivalent benefit necessarily means that the assumptions have to be quote unquote reasonable, which is what the plaintiffs are arguing. So there's no decision on that. I'm not aware of plans making dramatic changes to their actuarial equivalence factors yet. I think most employers are kind of on a wait and see status with respect to these claims. So finally, we have some fee litigation in health plans. This is actually pretty similar to the structure and the types of claims that have been made against retirement plans. So self-funded health plans are subject to ERISA. So ERISA's fiduciary duty and prohibited transaction rules apply. So again, those involve the duties of being prudent in terms of the use of plan assets and the duty of loyalty, acting in the beneficiary's best interest and the plan participant's best interest. And then when you have transactions between a plan and a service provider, it's a prohibited transaction subject to excise taxes unless there's an exemption that applies, and the usual exemption is the payment of reasonable compensation to a service provider. So you've got this question about, okay, is the payment of services with plan assets prudent, and is it reasonable under these prohibited transaction rules? And so like retirement plans, health and welfare plans pay fees to vendors. These could include claims administrators or other providers such as a pharmacy benefit manager, which we'll talk about in a second. Of course, the pharmacy benefit manager, or PBM, that's basically responsible for negotiating and handling the plan's relationship with prescription drug providers, prescription drug makers, pharmacies, and participants. And so there are a few things that have heightened the use of heightened I guess the focus on fees with respect to health plans. The Consolidated Appropriations Act includes a fee disclosure concept that's very similar to retirement plans. This is just the obligation, basically, that vendors provide a description of their compensation they're receiving from the plan. We call them 408(b)(2) disclosures in the retirement plan world, and it's basically the same for the retirement plans. This law added a subsection to 408(b)(2) that covers health plans. And I should say, by the way, I focus on retirement plans. If you have any questions about this, my colleagues Tripp and Brett are your go-to for these. I work less with health plans, but the ERISA implication of fees is very similar. So we not only have this 408(b)(2) issue, but we also have new fee transparency rules that require plans to disclose rates and costs in machine readable format. And again, this is all making the fees themselves, in theory, more transparent and more readily available to potential plaintiffs' lawyers looking to sue. We've heard late last year that there were plaintiffs' lawyers kind of actively recruiting class action members on social media for this type of litigation involving health plans and prescription drugs. It's kind of surprising that we only have one case so far, but there's a large case that was filed in February this year against Johnson & Johnson related to its use of a pharmacy benefit manager, and it's called the Lewandowski case. This is a current employee of Johnson & Johnson, and she claims that the health plan basically paid its PBM millions of dollars for prescription drugs that could have been purchased for significantly less. And they give examples in the complaint that are pretty eye-popping. There's one example of a 90-pill prescription for a generic drug where if you didn't have a prescription, or you didn't even have, I think if you didn't have an insurance, actually, if you go into a pharmacy, you could just buy this for $40 to $77, but the cost to Johnson & Johnson's health plan and its participants was $10,239 per prescription. So a significant difference. And the complaint says not a typo, which I thought was kind of funny. They're saying that difference is so dramatic, we're worried that you're not even worried that was a typo or a misplaced comma. The claim is that that's how much extra Johnson & Johnson and its participants are paying because of this PBM relationship. And so they tie this to ERISA and to the plan participants in a couple different ways. One, they say that inflated amounts paid with plan assets, this particular health plan is funded through a VIBA trust, which is basically the health and welfare version of a trust account. I think they did, partly why they sued this plan is that it makes it easier to say, look, judge, there were plan assets here that were clearly used to pay inflated costs. It's maybe a little bit harder to make that argument if there's no trust involved, but in theory, they could still make this claim against any self-funded plan that where participants have some kind of a cost-sharing obligation. They're paying their cost sharing through a Section 125 for plan, for example. Those are still considered plan assets. And in fact, part of the allegation in this case is that the plaintiff's saying, because of this dramatic prescription drug cost, my cost sharing is higher than it should be, which has the effect of lowering my wages. That's part of the claim that the plaintiff's making. Of course, typical as similar with 401k plans, the actual vendors, the advisors are not sued. The PBM is not named. The broker that recommended the PBM isn't named. It's only Johnson & Johnson and the fiduciaries who are in charge of the health plan that are named. So not only are the costs very high, which are translating to higher expenses for the plan itself and for individual participants, the allegation is also that this PBM model that they used was overly complicated and led to the excessive pricing described in the last slide. And what the plaintiff's pointing to here is something called a spread pricing model, where the PBM sort of negotiates the rates with the pharmacies and receives the difference in the cost between what the plan pays, what the plan pays the PBM and what the PBM pays the pharmacy on behalf of the plan. It's very confusing. If you go into the complaint, there are some decent diagrams that actually explain how this works. But the overall theory here is that it's just a confusing pricing model and there's inherent conflicts of interest. The prices are negotiated on what the plaintiffs maintain is the overstated average wholesale price. That's kind of like this agreed upon average wholesale price that the plaintiffs say is just always, not always, but can be artificially inflated versus what the actual real wholesale price is. You can see the quote there, the fourth bullet point down, that explains why the plaintiffs are claiming that this spread pricing is a way for the PBM to basically get more money from the plan and raise the cost of the pharmacy benefits. And then these PBMs apparently also own subsidiary pharmacies, so they're also getting kind of indirectly the difference between the retail cost and the wholesale cost of the truck. So the PBMs are getting paid a lot out of these relationships, is the argument anyway. And the plaintiff's also arguing that, hey, there's a simpler, more transparent way to do this, where the PBM basically just passes the cost of the drugs through to the plan and charges a fee. Simple. And according to the plaintiffs, again, this may not necessarily be true, but the argument is it would have been less expensive. And I'm sure the defendants will have an argument about why that's not the case, but that's currently the argument. So here we just kind of go through the litany of claims about this PBM arrangement, that the people in charge of the plan didn't really know how this pharmacy benefit program worked, or they would have never agreed to it. They kind of gave control over to the PBM, who was conflicted, failed to supervise the PBM, failed to supervise the people making this decision about how this arrangement should work, and just generally was asleep at the wheel, is the argument, with respect to how much the plan was paying for prescription drugs. And had those fiduciaries done more digging, done what the plaintiffs maintain is reasonable investigation, they would have taken a different approach. And so again, this is a new case. The allegations aren't proven. It's not even clear whether the case will go forward, but those differences, there are some pretty hair-raising allegations in the complaint. So I think there are a few things to just consider, given that this seems to be a new target out there with respect to ERISA plans. I mean, I think someone should do some investigation about what are your participants paying? Do you know what the participants are paying in terms of price, and how does that relate to the retail price? Kind of in reality, are participants paying this exorbitant amount and just no one appears to know it? That's something that you can probably do in-house fairly easily. Fiduciary training that we do in 401k plans, it may be worth having some discussions with the folks in charge of these arrangements to highlight the importance of negotiating the lowest rates you can for the services that are reasonable to the plan. Prescription drug pricing is very complicated, and it may make sense also to look at hiring an expert. If you've got a very large plan, that's inexpensive and maybe worth doing. A true expert who can look into those details, how the plan's paying for the drugs, what they should be, and what the average cost really is, may make some sense. The plaintiff also alleges in this case that the Johnson & Johnson did not do sufficient requests for proposals with respect to these pharmacy benefit services. They used a broker. The broker recommended this arrangement, and Johnson & Johnson accepted it, is the allegation. And the argument is that there's nothing that stops a prudent employer from doing more common RFPs for PBM services to try to lower those costs for the plan and for participants. Finally, there's an allegation in this case that the benefit consultant who was asked to assist was sort of paid indirectly by this PBM, or was paid to be kind of on the PBM's preferred list. And so again, part of the allegation is that the consultant wasn't motivated to drive the lowest cost because of that allegedly conflicted arrangement. So if you're going to retain a consultant, it's good to push that consultant to disclose any types of compensation they might be getting from these PBM providers. So I know that was a lot of information. We went a little bit longer than normal, but I appreciate your help and I appreciate your patience. And if there are any questions, I can take a stab at them now. Know that I have any. Let's see. So one person asked about forfeitures and whether they should be used or allocated at the end of each year. Can they be kept in the plan from year to year? At this point, they should be used. You should be trying to use those every year. Let's see. And that's it. So again, thanks everybody for joining, and we'll see you next time in July. Thanks. Bye-bye.